to human rights and religious liberty makes the United States a beacon of hope and freedom for the entire world. Of course, our pursuit of those ideals has been imperfect. At various times, we have discriminated against virtually every group of religious people. It is crucial that we learn from those mistakes. Two contrasting Supreme Court cases help illustrate how important it is to get religious liberty right, and how dangerous it is to get it wrong. The first is one they don't teach much in law schools these days anymore, but they should. Minersville School District versus Gobitis. The case illustrates what I would call the government control approach to religious liberty. The Gobitis case actually has its roots in Nazi Germany. As Hitler's Nazi party was gaining power, they crashed into a small religious group that had come from America called the Jehovah's Witnesses. In Germany, the witnesses refused to do the Heil Hitler salute to the Nazi flag. They thought it was the equivalent of worshiping a false idol. Not surprisingly, the Nazi government was not pleased. They threw many witnesses into concentration camps. They took their children away, sent them off to German schools to make them good nationalist Germans. The Nazis had government control, they knew how to use it, and they did not brook dissent. Back here in America, the Jehovah's Witnesses heard about all this, and though they didn't think our government was anything like the Nazis, they eventually decided that they shouldn't salute the flag either. And when two young school children, Lillian and Billy Gobitis, told their teacher that they couldn't salute the flag because of their religion, the Supreme Court got its first flag salute case. Sadly and wrongly, the court said that the government gets to control, even in matters of conscience. The court said that religious liberty was important, but then it said that legislatures and even school boards get to choose and have the power to decide when to coerce violations of faith. The court's ruling set off a wave of violence against Jehovah's Witnesses. They were physically beaten, they were dragged out of their houses, dragged into the streets and forced to salute the flag. Their houses of worship were burned to the ground, they were shot at. One sheriff explained why he wouldn't intervene to help them. Quote, "They're traitors. The Supreme Court says so." Thankfully, just 3 years later, the Supreme Court reversed itself in West Virginia versus Barnett. While Gobitis had embraced government control over everything, including your relationship with God, Barnett rejects that stingy view of liberty. Here's the famous quote: "If there is any fixed star in our constitutional constellation, it is that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion, or force citizens to confess by word or act their faith therein." In short, the court said that some things are beyond the reach of politics and government. The Bill of Rights must be respected and protected at every level of government and for every person. As you all frame the work you will do on this commission, I urge you to embrace the principled Barnett approach to liberty. That is not always easy. Governments often think some other value ought to rank higher than respecting religious freedom, especially for someone with unpopular religious beliefs. Please do not accept the sacrifice of religious liberty for political convenience. Don't accept the government control approach of Gobitis. That is a cheap counterfeit of liberty, and you all were not called to this commission to serve a cheap counterfeit of liberty. America's overall story of religious liberty is quite positive, but since you asked for recommendations, let me give you 3 recent examples of places where our society has fallen short. After the October 7th terrorist attacks in Israel, many American college campuses succumbed to horrific anti-Semitism. Jewish students were harassed, swastikas became common. At UCLA, there was a Jew exclusion zone in the heart of the campus. Shockingly, UCLA used its police force to turn Jewish students away rather than helping them through. In another case, courts recently turned their backs on the Western Apache people, refusing to protect a sacred site where they have practiced their faith for generations. Now that holy ground is in danger of being destroyed so that a foreign-owned company can extract copper from it. And you are likely familiar with the plight of the Little Sisters of the Poor, Catholic sisters who provide loving homes for the elderly. State and federal governments have been trying for more than a decade to force the sisters to help distribute contraceptives and abortion-inducing drugs. Even after 3 wins at the Supreme Court, the Little Sisters are still fighting hostile state governments in court today. The greatest and freest nation on the face of the earth can do better than fostering anti-Semitism, destroying sacred sites, or pretending we need to force nuns to give out birth control. Governments and bureaucrats will always come up with some reason they don't need to respect religion. This commission should make clear that conscience is sacred, and you should call our great and diverse nation to work with our religious differences rather than stamping them out. Remember the example of George Washington. Even when our nation's very existence stood in the balance, he respected the religious conscience of Quakers who could not bear arms. This commission should call us all to live up to that legacy. Let me make one closing point about why protecting religious liberty is so important. The entire edifice of rights in America is based on the understanding that God created humans free and equal, and that our God-endowed inalienable rights come from that intrinsic human dignity which every person shares. We see this argument in foundational American documents like the Declaration of Independence. It was also the basis for the Quakers' early petitions against slavery, petitions they were only around to make because of our early commitment to religious liberty. The late Rabbi Lord Jonathan Sacks of the UK put it this way when receiving the Canterbury Medal for Religious Freedom, quote, "In America, the tree of liberty has religious roots. Don't think you can sever those roots and have the tree of liberty survive." Religion and religious liberty give us a foundational commitment of equal respect and human dignity for everyone, including the people with whom we disagree. If religion and religious liberty are wiped away, there is no reason to expect that people will operate from that same foundation of equal respect for the human dignity of all, especially when we disagree. We don't want to live in that nasty world, and we don't want to leave it to our children and grandchildren either. The great American commitment to liberty means there are places in our lives where the government is not allowed to go. There are rights that the government is not allowed to take away. No other country in human history has protected human rights the way America has, and no other right is more essential to the perpetuation of that system than religious freedom for all. That is the legacy of liberty to which all Americans are heirs. That is the legacy of liberty that all human beings deserve. May God bless the work of this commission to advance and strengthen that legacy for future generations. Thank you.
Thank you, Mark. We will hold questions until our second witness, Gerald Bradley. Gerald?
Thank you, Governor Patrick and members of the Commission. America's founders were pioneers of religious liberty. Unlike practically all societies before theirs, they rejected top-down control of the people's religion through princely imposition or by the union of altar and throne or by enforcement of some eclectic civil religion, or by all three, as in England circa 1776. But the idea here in these societies was political prosperity through religious unity. Now, unlike most free societies after theirs, our founders did not secure religious liberty by erecting what Ryan Anderson's old boss, Richard Newhouse, dubbed the naked public square, a secularized space from which religion is banished. The idea here is political prosperity without religion. This idea was the Supreme Court's mid-20th century point of departure. starting in earnest with the school prayer case in 1962. The founders rejected these false alternatives. For them, it was not either public religion without freedom or freedom without public religion. The founders went all in on both and. They steadily maintained, in the words of the first Congress, which wrote the religion clauses into the Bill of Rights, that religion was necessary to both the happiness of mankind and to good government. America's founders launched an epochal, novel experiment in human rights and civil liberty, an experiment which by world historical standards has been a singular success. Now, what emboldened our founders to blaze the path of religious freedom? They were political savants, to be sure, but they knew their history, too. They knew that the politically savvy move was to control religion from the top down. So again, where did their extraordinary political courage come from? Well, their trust in divine providence is surely one reason. But providence is fully compatible with human persons' free cooperation in God's plan. Indeed, providence presupposes that freedom. God helps those who help themselves. The founders chose freely and without precedent the epochal, uncharted path of freedom with eyes wide open. But why did they do that? Because they were convinced that government's obligation to preserve and protect religious liberty is a true principle of justice and political morality. Freedom of religion for all is the only valid conclusion they could draw from a series of truths they held most firmly, though I think not, as a matter of fact, self-evidently, but call the nest of these truths, these propositions, the moral foundations of religious liberty. Now, where shall we look for a compact expression of them, those moral foundations? Well, we could look to the founding generation's preeminent guide to constitutional meaning, to the guiding force behind our First Amendment, and to the author of what the Supreme Court, or what Supreme Court justices, liberal and conservative, have all treated as the Magna Carta of American religious liberty. I speak not of three men here, but of one, James Madison. And I speak of his 1785 pamphlet against the Virginia tax for the support of ministers, the pamphlet called The Memorial and Remonstrance. And indeed, I'll just talk about the very first paragraph of it. Madison wrote that religious liberty is not about the sovereignty of the human person, what we might call subjective right. Much less was religious liberty about that idiosyncratic creativity expressed by the Supreme Court in 1992 in its infamous or famous mystery passage. For Madison and the founders, there was a sovereign in the picture, an omniscient and good one. Madison wrote, "Before any man can be considered a member of civil society, he must be considered as a subject of the governor of the universe." Now, this subject was not for Madison or the other founders a law unto himself. Religious liberty as an inalienable right, or was an inalienable right according to Madison, because, Madison wrote, what is here a right towards men is a duty towards the Creator. This obligation is not like other important moral duties, which one fulfills by inaction. Thou shalt not. This duty to the Creator is a much heavier lift, and it's inalienable for a second reason, Madison wrote, because the opinions of men, depending only on the evidence contemplated by their own minds, cannot follow the dictates of other men. This freedom of conscience, conscientious belief, is not a license for indifferentism. It is an overriding call, moral call, to knuckle down and get serious, to do some very hard thinking about divine realities. Now, central to religion is one conscientiously judging what is the case about ultimate matters, and then acting according to what one judges to be the case. Now, this obviously can only happen if people are free of coercion and manipulation. Madison wrote, "It's the duty of every man to render to the Creator such homage, and such only as he believes to be acceptable to him. This is a duty that can only be fulfilled by free thought, judgment, decision, and subsequent action of each person. No one can perform it for you. If you don't do it, it don't get done." Now, note well, these moral foundations were not held by the founders as truths of religion. That was about what the denominations and the sects taught, revealed doctrines, the deliverances of prophets and sacred texts, ceremonies and charisms, and church precepts. The moral foundations of religious liberty, as we find them in Madison and across the founding, comprises truths about religion, about divine realities, human intelligence and free choice, and the political common good. These the founders thought to be truths to be accessible to unaided human reason. They're really more truths of political theory or actually of philosophy, not religion. So for that reason, there can be no sound argument, none that I can think of, that recovering these moral foundations of religious liberty, these truths about divine realities, human life, and the political common good, amount themselves to some sort of religious establishment. And we certainly should not suppose that Madison, for example, was foolish enough to argue for religious liberty in a memorial remonstrance on grounds that we would call or would sound to people like a religious establishment. Now, the founders resolved to let the spirit of human inquiry and judgment blow where it wills, in the end because they were obliged to do that. Obliged not by superior force, or even, so far considered, by any revealed or revelatory act of God within human history. The founders were obliged by reason and conviction. They were compelled by truth. Now, the founders recognized two entailments, I'll call them, of what they wrought: their settlement, their experiment in religious liberty. One thing they recognize is this: unleashing the potentially disruptive forces of felt spiritual imperatives is risky. It is. So risky that no polity before theirs ever did it. Second, the founders recognized that in a free society like ours, the restraint, the virtue really necessary to good order, has to come from the character of the people, not from government dictates. At the intersection of these two lines of thought, these two entailments, stood religion. The founding generation all but universally held that the political common weal, common good, depended upon the piety of the people. This is the message not only of Washington's justly famous farewell, the message of John Adams, it's the message also of Thomas Jefferson and pretty much everybody else at the founding. This pervasive judgment that religion supplies the ground for virtue, and virtue is necessary for freedom. This pervasive judgment, I would say, is not quite a moral foundation of religious liberty. I rather think of it as a morally adjacent truth of political wisdom. But there it is, nonetheless. Now, someone might now reheat an anti-establishment objection and serve it up right here against what I've been saying. Someone might say these affirmations about divine realities, etc., lack, if they're a basis for government action, lack a secular purpose, which is required for every government action. Now, this was indeed a demand for an unfortunate season of the Supreme Court's late, and I dare say unlamented, Establishment Clause test, the infamous three-part Lemon test, which was a gigantic mistake, which Justice Scalia 30 years ago likened, in his usual colorful language, Scalia speaking, the Lemon test is like a ghoul in a late-night horror movie that repeatedly sits up in its grave and shuffles abroad after being repeatedly killed and buried. Well, to continue with the colorful prose, finally the Lemon test has a stake buried through its heart, and it's really, really dead now. Now, the secular purpose objection, the secular purpose part of the Lemon test for that matter, I think is, in any event, question-begging wordplay. The wordplay goes like this. You see, religious and secular are opposites. So if government should act for the sake of religion, they must not be acting for a secular purpose, even if acting for religion opens onto or produces what we might call secular prosperity in a wide sense. Well, we don't need to think that way, and the founders most certainly didn't think that way. Let's instead work with the founders' words and concepts and think about government promoting religion for the sake of the common good. Now, the founders were keenly, even fearfully aware of the divide between this passing veil of tears and what they ubiquitously referred to as, the founders' terms, a future state of rewards and punishments. But the founders never used the term secular when they talked about religion and the polity. The closest they came to doing so was probably references to what they called worldly activities, which were mostly forbidden, on the Sabbath. For the founders, proper government care for the temporal common good included encouragement and help and recognition of religion, albeit always respectful of persons' freedom and churches' autonomy. In the founders' world, deploying the word secular would have added nothing to the discussion and probably confused everybody party to it. Now, in conclusion, I've spoken so far. I haven't really spoken specifically about constitutional interpretation of the religion clauses. And I should like to close by noting two takeaways from my remarks pertinent to constitutional interpretation. One is this. It's folly to think we can jettison what I've called the moral foundations of religious liberty and its moral adjacent, the people's virtue. I think it's folly to think we can jettison that is banish it from our thinking, and remain faithful to anything like the original understanding of the religion clauses. The other takeaway is that no matter what is true with other constitutional provisions, here at the keystone of our constitutional civil liberties, here with religious liberty, there is no need for the contemporary interpreter on or off a court, interpreter of the constitutional language, to choose between history and justice, to choose between historical recovery of the plain meaning of the text and what surely appears to be the moral truth of the matter. For in the case of the religion clauses, the founders wove truth into the text in a tapestry for the ages.
Thank you. Kelly?
I guess I have a question for each. First, Mark, first, thank you for literally a life of service for religious freedom and what you've done. I really do. I'm thankful for both of you. Mark, I want to start with you. I know Ms. Ho mentioned in her opening remarks this issue, and since you litigate in this area, of judges trying to avoid and creating things so that they don't rule for people in these cases. I'd just like you to give your experience on that, whether you think that's true, and then if there's any recommendation or anything you have that we could recommend to the president. I don't know if there is, but I think there could be. And then Professor Bradley, I know this afternoon we're going to get to more cases and all this, but you've had such a wide background on this. I would love to get your idea. You mentioned the Lemon case being overturned and our Kennedy case that we did a few years ago, but what do you think is the next big thing that should go if we're going to have more religious freedom? And then if you have any ideas how to move us in that way, I'd love that as well.
Thanks, Kelly. Happy to discuss it. You know, there's something that I think is true of judges, but I think it's also true of people who work in all levels of state and federal government, which is sometimes you get up or sometimes you encounter a situation and you're just not all that eager to do the job. And I think one thing this commission can and should do is call on all of our public servants, and I really do think it's across the board, to remind them that they have an obligation, right? I mean, if you wear the robes or if you took the oath of office to be a state legislator or a federal legislator, or you work in the agency someplace, you have a duty to advance and uphold religious freedom for everyone. And that means you have a job to decide the hard cases and to work through the difficult situations. Nobody ever said this was all easy or simple. Nobody ever said every case was easy or simple. But nothing gets better when you kick those cans down the road and say, well, you know, we'll let a few more families get messed up or a few more churches get closed. That's not a win for anybody. So to the extent this commission can highlight those things and encourage people to really do the job, and letting things linger for a long time, you know, choosing to not decide to let parents have their rights to raise their children the way they want, for example, that's just harming people, and our whole system of government should do better.
Kelly, to put it bluntly, I think it's time to kick in the rotten door that's barring religion from the public square. And what I mean, maybe a little bit more helpfully than that, or less cryptically than that, over the last 20 years, the Supreme Court, at the behest or at the urging of people like Mark Rienzi, the Becket Fund, ADF, First Liberty, has issued a series of rulings that bit by bit have reintroduced religion into the public square. And finally, the court has overruled the Lemon test, and it's the first part of it is government has to have a secular legislative purpose. But the Supreme Court has done everything to prepare the way for it to say something now, which it has yet to say, and should say, which is that promoting religion for the sake of religion and its ulterior benefits to the polity is fine. To date, even with the many good decisions we've had in the 21st century, the Supreme Court would still is beholden to a view that I would describe as a kind of hangover of secularism, that it's always looking for a secular side benefit or collateral effect of action that government takes, which has in some way an effect of promoting religion. We're always looking to call legislative prayer, for example, a way to solemnize the occasion, for example, rather than say, we're praying here. So everything is set for the court to do that, and I think it should do that at the earliest opportunity.
Dr. Anderson?
Great, thank you. I thought both opening remarks were outstanding, and so thank you both to Mark and Jerry. And I have a question for each of you. Mark, at one point you mentioned just in passing that government can't violate religious liberty except for certain rare exceptions. And sometimes I think thinking about those exceptions can actually be really helpful for highlighting what the foundation is. The way that I've thought about this in my own kind of research and writing is that all of our natural liberties have natural limits. And so government isn't violating my natural right to free speech when it says you can't publish obscenity, because the right to free speech never included obscenity to begin with. Doesn't violate my liberty when it says you can't rape, pillage, and plunder, because I never had a liberty right to rape. So what are those natural limits to religious liberty? Just so we can think through, like, what is within the scope and what's outside of the bounds. And then, Jerry, I love your, some people want to have public religion but no liberty. Other people want to have liberty but no public religion. The founders wanted both. Can you help us think about how we've done that historically? How have we as a nation both promoted religion publicly and respected and protected religious liberty?
Thank you, Ryan. Here's the way I would suggest thinking about the limits on religious liberty. Like, when can the government force somebody to violate his or her religion? The short answer is it should be very, very rare. It should be where there's something the government needs to achieve, and the only way to do it is to force someone to violate his or her religion. So if my religion is to sacrifice children to Moloch or to drive the wrong way on the Beltway when I get out of here this afternoon, I don't win that case, right? The government has a compelling reason to stop me, and it really has to stop me. Otherwise, I'm going to kill other people. Otherwise, I'm going to do something terribly dangerous. That's almost never the case in most religious liberty cases, because thankfully most people don't claim a religious right to kill their children or drive the wrong way on the Beltway. Here's one benefit to massive, overwhelming government that is involved in every aspect of every one of our lives, right? We probably all have different opinions on that. My opinion's kind of negative toward that. But here's a positive about it, right? The massive government that has 9,000 tentacles and has 50 zillion agencies you've never heard of, guess what? It can get its work done without forcing nuns to give out contraception. It can get its work done in almost every single case without forcing American citizens to violate their religion. And so in an era of big, powerful government, the answer is those limits are really rare, because almost all the time the government can get its job done without coercing violations of faith.
So the best way I can answer your question, Ryan, is to take two traditions, which are vibrant traditions from the founding on until sometime within the memory of some people still living, like me. Now, these are two traditions that have been battered and limited and diminished by Supreme Court decisions, other court decisions, government action of a general kind, and also the cultural drift away from religious observance. But I think both of these traditions are still alive and should be revivified. Now, one is just a tradition of public recognition of truths about divine realities, starting with prayer in legislative assemblies, chaplains in the military, but also in public speeches and public expression. I mean, it's not that long ago where the terminology of providence and, for the most part, in fact, biblical faith, were a part of political discourse. And I don't mean just the high points like Lincoln's second inaugural, which is justly famous for its sort of awful rendition of providence and divine judgment. But there is a tradition of recognition of these truths of philosophy, very often called natural religion, which were part of the civic furniture for hundreds of years, and now remain almost as bleached or whited sepulchres. So as I said, not puckishly to Kelly, more seriously, the Supreme Court has upheld legislative prayer on the ground that it's not really prayer. It's a kind of sacred sounding verbal salad, which has the effect intended to settle down people, to signal the meeting is beginning, and solemnize the occasion. So we could revivify this tradition, but not be embarrassed by it. And the other is to continue, revivify, but continue the tradition of what you could call government religious partnerships, which are present at the beginning. And at a time, and for most of our history, the federal government, I know it's hard to believe for people present, the federal government's budget wasn't in the trillions back in the Washington administration. The federal government had very little infrastructure or capacity to do anything that we would call social service work by itself. So there was a tradition from the founding until the day before yesterday of creative partnership between government and religion, religious groups, religious bodies, to supply social services, education, etc. Now that should be done, and all of this should be done with respect for people's freedom. So none of this suggests in the slightest, or I don't think it should suggest in the slightest, that Jehovah's Witnesses school children should actually be compelled to salute the flag after all, because they're truths of natural religion. No, but all of this should be respectful of people's freedom and also of a kind of non-discrimination among the religious groups. But both of those traditions have enough life in them, enough of a pulse, that they could be revivified and should be, and would be with less effort if the Supreme Court finally pivoted and said, you know what, we're kicking in the rotten door. It's fine if government works with religion, even for the sake of religion.
Dr. Carson, and then Rabbi, and then Allison.
Well, thank you both for very enlightening answers. I have a question for each of you, but either can feel free to weigh in on the other's question too. For Mr. Renze, You say we can learn a lot from what's happened in the past. The Puritans were basically good people, and they wanted everybody to be good people. So they kind of decided who would be the good people and what the criteria were for that. And they punished people who didn't necessarily comply with that. What happened to them to make them so intolerant, and what can we learn from that? And then for Gerald Bradley, is it possible for the government to promote religion without infringing upon the rights of others?
Thank you, Dr. Carson. Yeah, the Puritans are humans, right? They're humans like the rest of us are humans, and they succumbed to what I think is a very common temptation that in many ways the American experiment fights against, right? So the Puritans come over here seeking religious freedom, but then when they get here, right, they don't necessarily provide it to people who have different beliefs from them, and they're bad to the Quakers, among others, when they get here. A similar thing happened in Maryland, which is established initially with religious tolerance and then kind of flips back and forth. So I think our early history shows that there's a long-standing aspect of human nature that says when you're thinking about religious truth and you say, I have figured it out and I know the truth, then you say it's my job to stop the other guy from doing other. And I think that's a bad path, and I think one of the great achievements of our country is that we eventually kind of, restrained that aspect of human nature and said, actually, everyone should be able to freely seek God and freely, as Jerry was citing James Madison, freely respond to the duty to the Creator, and that the power of government shouldn't be crushing someone who has the wrong views. And I will say that strain of human nature, right, which was initially wielded by the Puritans against the Quakers and others, and I think it originally comes from fervent religious belief, right, conviction that you're right, and therefore I must crush the guy who's wrong. That has lasted, but these days, frankly, I don't think it so much comes from religious people trying to use government to stamp out people with unpopular views. I think it's now more often anti or a-religious folks who want to wield the government to stamp out views that are wrong. And I think the truth is, whether it's the religious people or the opponents of religion, it's wrong, and it's wonderful that the United States has moved away from that, and we should continue trying.
Well, it's not only a terrific question, it's a question. How does a government which takes my advice and decides to reclothe the public square with religion avoid violating the rights of people, maybe especially non-believers, but let's just say the rights of people? And that is the kind of thing where I think if I were watching a TV commercial, this is where it would say, this is an expert driver, don't try this at home. That is to say, before you try to promote religion, you better give a lot of thought to how you're going to do it without compromising people's rights. Now, I think it can be done, but it is something that has to be considered carefully for the very good reason that Madison cited. I mean, I don't think God wants insincere religious worship. I don't myself think God wants people to worship because that's what's done around here. I think worship that's pleasing to God, this is my own conviction. I don't know what Madison for sure thought, but my own conviction is that's what God wants. He wants people to freely come to God with conviction, owning their religion, believing in what they're doing. So you might say, I think believers need to constitute themselves and own their religion, and that can't be done save freely. So for the sake of religion, it is religious freedom. But one way that we can promote, I think we can see our way to promote religion respectful of freedom, but in a way that doesn't compromise anybody's rights, is to maybe repackage something that Madison said. He certainly held it, and what I was trying to say, which is this: we should come to recognize religion as a common good, even if not everybody's religious. And even if some people, maybe they're not religious, don't think religion is a common good. Quite a lot like education. I mean, we do think of education as a common good, and government does a great deal to supply it, promote it, and pay for it. I'm not saying that's exactly what we should do with religion, but even people who don't believe in education or think that universities are half frauds and half dangerous, any number of people may have reasons to think that education as it's practiced today is not a common good, but really just what some people have managed to get the government to pay for them. But I think that's false. No matter what you think of today's educational system, having an educated citizenry is good for all of us. It's good for democracy. And as the founders most certainly did think, and I think, having a religious and virtuous citizenry is good for everybody, frankly, even people who lack virtue and don't believe in religion.
Yes, Dr. Phil?
In the interest of just kind of having a conversation before we move on to the next question, can I ask a follow-up here?
Yes, yes, of course.
Because we're talking about the government promoting religion, and that kind of gets a little scary sometimes, promoting, because nobody's a blank slate, and excuse me, and everybody comes to a situation with a bias. Nobody is bias free. Everybody has some preconceived notion of an issue when they come to it, and when you see people behaving some way in pattern, then those in power are either eliciting, maintaining, or allowing that in some way. They're not neutral. They're either eliciting it, or they're doing something to maintain what's already happening, or they're at least passively allowing it to go on. There's some role. You cannot not choose. Not choosing is a choice, right? That's the fifth choice. You can come to the crossroads out in the middle of the country. You can go left, right, back, or forward, or you can just stand in the middle of the intersection and get run over. That's the fifth choice. You cannot not choose. So, and when you say to promote, are we talking about promoting religion, or are we talking about promoting liberty to choose religion if that's what you choose? Because if we're promoting religion, that's different than promoting choice. And I'm curious, what is it we're promoting? If you're saying promote.
Well, I think I might disagree with you. I think I understand what you're asking, and it deserves a better and a richer answer than I can give it, at least in these time constraints. But I don't think I agree with you that there's a tension or a difficulty with envisioning promoting religion. At the same time, you're promoting its free observance and appropriation by people. And an example that may be illuminating, it's not an analog, but it's something similar, would be family and marriage. I mean, the government, a political community ought to promote marriage and family as good things and help people who choose to be married and to have a family successfully do so. So there are aids to education of children and all sorts of possibilities for benefiting married couples. But nobody has to get married. In our country, you're free to reject marriage. You're free to think marriage is just another scam by the man. You're free to do that. But nonetheless, I think we do promote marriage and family. We should promote marriage and family. But I think it's fair to say you're free to decide that for yourself. Not only in terms of getting married, but also whether you agree with the government's promotion of marriage as a good thing. You may think it's not.
But are you saying that's true for religion as well, that we should promote religion, but yet people are free not to do it if they want to?
Pretty much. I mean,
I
promote it as
agree.
a good thing. It's a good thing, but it's not. It's only a good thing if people choose to buy into it. Education, to some extent,
I
is
for
that
one
way, too.
think my bias is that religion is a good thing.
Yeah.
And for the first time in our country's history, participation in organized religion has dropped below 50% for the first time in our country's history. Now, there's a lot of reasons for that, and probably the most operative is that our birth rate has dropped so low, and the reason one of the primary reasons people join the church is to have their children baptized or, whatever. So that may be the most operative reason, but nonetheless, it's dropped below 50% for the first time in our country's history, which I think is a very sad reality, because that's a great glue, as I said earlier, that holds the family together, and they worship together, and there's also the sense of community that comes with that quiet time together and coming together as a community. So I personally have, my bias is that it's a good thing, but I don't know that everybody would share that. That would be my bias if I was bringing it to the situation.
I agree.
Thank you.
Thank you, Dr. Phil. Rabbi?
Thank you, Chairman. Excuse me. I'd like to explore, building on the eloquent testimony of both witnesses, the connection between free exercise right and other aspects of the Bill of Rights. So, Mr. Rienzi, you movingly referred to the story of the Gobaitis case and then the Barnett rectification of Gobaitis. So let's use that for a moment to explore the connection between free exercise and free speech. In one of the lamentable religious liberty decisions by the court that still has yet to go, Employment Division versus Smith, the majority in that case argued, among other things, that the Barnett case, the pledging allegiance case or saluting the flag case, is a special case because it is what the court called one of hybrid rights. It involves not only religious liberty but also freedom of speech, to which Michael McConnell, I think, rightly responded that, in truth, acts of religious exercise are very often, if not almost always, also forms of expression. If I am wearing a yarmulke or one is wearing a cross, obviously one is not just engaging in a form of religious observance, but of expression of faith. Pastor White referred movingly to the case of one being prosecuted for silently praying, which is, of course, both a case of religious liberty as well as speech. So I'm interested in the intersection of religious liberty and religious speech. And then regarding Professor Bradley's testimony, which I'm entirely in sympathy with in terms of rediscovering a better understanding of the role of faith in society and government's role in helping to bring about that. I'd love some thoughts on what would a better understanding of the Constitution's reference to a prohibition on religious establishment actually be. Members of the Commission have themselves referred to, as Tocqueville did, the importance of the separation between what my colleagues called altar and throne in America. On the other hand, we've clearly gone wrong somewhere. I think George Washington, who wrote that wonderful letter to the Jews of Newport, would be a kind of surprised to learn that the Supreme Court had decided that, say, a rabbi giving a non-denominational prayer in high school graduation, or a state legislature creating a school district to help special needs Hasidic children, was considered by the courts a dangerous encroachment on constitutional boundaries, and yet we've had those decisions. So, what would a better understanding of the reference to religious establishment be, and how would that relate to a better facilitation of faith in the public square? Mr. Rienzi, maybe we'll begin with you.
Yeah, so Justice Scalia, who wrote the Smith decision, which was a mistake, in a different decision said, a free speech clause without religious speech is like Hamlet without the prince. And he was right then. He was wrong in Smith, but he was right about speech. Free speech, parental rights, all sorts of other rights are very, very closely tied to religious liberty. And when you cut back on religious liberty, you endanger the others. Religious liberty also can't just be an equality right. It can't just be, we got to treat everybody the same. That would work if we all had one religion. If we all had the same religion, then treating us all exactly the same would protect each of our free exercise. Like that would be fine in a place where we were twins. But we're not, right? This is a religiously diverse place, and so to protect religious liberty for a religiously diverse people, you're going to need to protect something different for the Muslim and for the Jew and for the Native American and for the Catholic and for the Protestant and everybody else. And so when we artificially shrink our rights down, and when we cut them down to something like just an equality principle, and we don't give full protection to the free exercise of different religious faiths, we're really shortchanging the religious liberty right, but also things like speech and parental rights that are really the bedrock of our civilization.
Thank you.
Members, we're pushing the clock just a little bit here on our first set of witnesses, and we just want to stay on time. So Allison and the bishop will close it. And is everybody else okay? Paul, did you have a question? Allison?
Thank you, Mr. Chairman. Ideas have consequences, and what happens in the ivory hallways of the academy and courtrooms doesn't stay there. It has real impacts on real people. And I was struck that both of you, when you were referring to religion, Mr. Renzi, you spoke of it as a freedom to live out our faith. Professor Bradley, you talked about acting on what one believes. And it seems to me there's a misconception that religion in the clauses is really limited to worship. And I think that really expands the power of government and how it can intrude on the sphere. At the same time, it shrinks individual liberty and freedom. So I just wanted I'd love to hear both of your thoughts on that problem and what we can do to sort of restore a more proper and capacious understanding of religion.
I'll just say simply that, one, that's a great point, and one that it would be great for this commission to work on emphasizing and making in public quite a bit. And the easiest answer is that the word is exercise, right? It's the free exercise of religion, which means not just you get to believe whatever you want in your head, but you get to act like it's true within very, very broad limits, right? For the most part, you get to do that. And so if we're going to protect the free exercise of different religious beliefs, we're going to have to give room for people to act on them. And I agree with you, sometimes our courts historically have had a much smaller scope for that, right? You can believe what you want, you can tell your kids when they get home that they were sinning, but when I get them back in the schoolhouse, I get to make them do what I want. That's not liberty.
I think it's probably true, Commissioner Hode, that at the founding and for a long time thereafter, public worship was the quintessential religious activity or central religious activity. There was a way in which it had a certain priority of visibility and perhaps importance. So there is some reason to treat it as primary, but not any reason I can think of that's a good reason to treat it as somehow exclusively what religion's about. Religion really, I think, is about self-constitution, vis-a-vis transcendent source of meaning and value, and whatever one holds that to be. So it really involves organizing your entire life around a connection and an attempt to be in harmony with God or the transcendent principle or whatever you call it. Now, obviously, there are a dramatic number of limits on anybody's freedom to do what they want, but I do think that there is a material in our tradition that should be emphasized, and it goes all the way back to the founding, of religion being a kind of encompassing part, not an encompassing part, but really the encompassing canopy of one's entire perspective and existence. Again, it doesn't mean that it doesn't have any anarchic implications. There's order and there's respecting other people's rights, to be sure, but I think we should treat worship as, maybe even today, somehow prototypical or central, but it's a mistake to make it the sum and substance of religion. And it's just a mistake.
Bishop? And if on your answers, you can give us good answers now a little bit at the end. You guys have been terrific, so just we'll make a little succinct. Bishop?
Yeah, thank you, Mr. Chairman. Thank you for the two presentations. I found them both really stimulating. As you were talking, I kept thinking about the great Vatican II statement, Dignitatis Humanae, on religious liberty, one of whose principal architects was the great Jesuit John Courtney Murray, who argued a long time ago that the principles of natural law provide a sort of basis for peace among, let's say, the potentially warring religions, a sort of common moral consensus, natural religion, if you want, and all that. It seems to me everyone around this table would kind of hold to the principles of natural law. But you also cited the famous, infamous Casey decision in 1992. It belongs to the nature of liberty to decide the meaning of my own life and the meaning of the universe, this wildly over-the-top statement, which is now, it seems to me, the default position of almost every teenager in America, right? I decide everything. Here's my question. What do we do when the natural law consensus has evanesced, which I think it largely has among a lot of people in our country? Because religious liberty, as we've been talking about it, as the founders talked about it, as John Courtney Murray talked about it, is grounded in this shared consensus. What do we do? I think that's our challenge. What do we do when Casey versus Planned Parenthood is now the default position of most people?
You fight back against it with truth. The truth is the Casey principle is an empty thing to organize your life around, and you stand up and you say it as often as you can until people see it and realize it.
I agree. I mean, I think the Casey principle is basically, it's a value judgment. It's not in any way neutral. The value judgment is everything that counts in what you do and what you believe is authenticity, that it's really you. What it is you believe and do doesn't much matter at all as far as value is concerned. It's all about your individuality and asserting your stance and identity. I think besides refuting it with truth, and this is maybe not in a way helpful advice, but I think we're seeing it sort of run its course already. It's demonstrating itself to be an empty promise of creativity and authenticity. It's actually a dead end and kind of a prison of emotion and something else. So, and again, I wish that the end of this course would come sooner rather than later, but I dare say we're on a course, it's on a course to a kind of extinction.
Last quick point I'd make is if you want to figure out what's been wrong for the last 30 or 40 years in our law, it was that Casey gives that view of liberty at the same time that, until the last 15 years, we had a stingy view of religious liberty that was actually directly protected in the text of the Constitution. That's a problem. That's something this commission should help us straighten out.
I am going to recognize Carrie because you were way in the queue earlier and I missed you, so go ahead.
Thank you. I wanted to know about the Supreme Court case in 1962, the prayer case. Do you believe, I would like both of you to answer, do you believe and recognize that after that case, we saw a significant decline in morality? We saw suicide rates increase, we saw teenage pregnancies increase, we saw divorce rates increase. Do you believe that prayer should be included in school as it was for 200 years when the students used to read the New England Primer and obviously have prayer in school and have the Bible as their textbook? What significance do you believe and detriment did the 1962 Supreme Court case have on all Americans?
Well, I myself treat that case, apart from the particular context prayer in schools, which, as you're saying, or suggesting is an immensely consequential thing. I do think that was the real declaration of independence by the justices from the constitutional tradition. They had indicated this direction as early as 1947, but the Engel case in 1962 is where the Supreme Court just cuts itself off from the tradition and declares itself the harbinger or custodian of secularism. So I think it's a bad decision for that reason. The other thing I say, I don't myself know what the consequences or what cause and effect is with regard to the consequences after 1962, and I don't dispute or wonder about anything you said. But I would add this, that the Engel case, which is the 62 school prayer case, I should say, the Supreme Court decided that on the assumption, they took it over as their given, that it was truly voluntary prayer. Now, some people may doubt that that's the way it works in a grade school classroom, but the Supreme Court decided that case on the grounds that it was voluntary prayer, which it would have to be in light of the Barnett case from 1943. And the content of the prayer in 1962, the New York Regent's prayer, was little more, wasn't anything more than a short collection, compact collection of the truths that Madison and all of the founders affirmed. Almighty God, we thank you and we implore your blessings upon our country, our families, and our community. Almighty God, we give our thanks to you. And it really is just a recognition of God's existence and providential care for humankind. So it wasn't a prayer that should be called sectarian. Even in contrast to the 1963 case, the Shemp case, which had to do with Bible reading from the King James Version of the Bible. That's actually a different situation. But the New York Regent's prayer case, Engel, I think, was a sharp, bad turn at several levels of thinking about it.
Thank you. Thank you, Kerry. I just have one quick question with a short answer, if you can. Almost every decision that has been made regarding religious liberty has come from the courts. Almost every decision that has taken the wrong turn at the court level. The founders believe this should be left to the states and the state legislatures. Do you believe if the courts had stayed out of this, which they had for a long time, and left to the will of those elected by the people, that the legislators in this country would have made these same decisions and passed these same laws? And I say that coming from Texas, where we just passed Senate Bill 10 to put the 10 Commandments in every classroom, and Senate Bill 11 to put prayer voluntarily back in our schools. Because I question if the Congress or if state legislatures would have done what the courts have done.
I don't know if they would have done what the courts have done either, but I'd caution that I think it's a dangerous world to say we want the courts out of these things. I think the point of the Bill of Rights is that there are some principles that everybody's supposed to apply, but the courts ultimately do need to protect and step in occasionally. The law in Gobitis was from a local school board and legislature too, so I think sometimes those entities will get it right, sometimes they will get it wrong, but I do think we need a system that protects minority rights and sort of ensures that they get it right. All that said, courts obviously quite often get it exactly wrong, and that's dangerous, and that's why we have to work hard to fix it.
Yeah, I think there's an essential, an important role for courts. I agree completely with Mark Rienzi. The only thing I would add, it's an adaptation of something that is attributed at least to Bill Buckley, which was Bill Buckley said at one point he'd rather be ruled by the first 200 people in the Cambridge phone book than the Harvard faculty. My adaptation of it is to say, I think over the last 2 generations, we would have been much better off, all told, with regard to religion, if the people had had more to say about how we would integrate religion in public life than the courts, in fact, have had over the last 2 generations.
Well, and Harvard is obviously still a problem. I want to thank our 2 witnesses. Please give them a round of applause. Thank you. Thank you. You may be excused. I'm checking because I can't quite see, it's dark backstage, if our Attorney General is here yet. Do I have any staff update on that? Our next witness is Dr. Mark David Hall, a professor of Regent University School of Government and an acclaimed expert in American political theory and church-state relations. Dr. Hall has authored or co-edited a dozen books on topics central to religious freedom. His work will provide essential context as we examine our founders' vision for religious freedom. Mark?
All right. Well, thank you very much, Chairman. Is this on? All right, fantastic. Well, and thank you, members of the Commission, for your very important work. It's my honor to be before you today. So I've been asked to say a few words about the original understanding of religious liberty in church-state relations. And as a scholar, I'm happy just to do that. But my wife is always getting after me, why is it relevant? In this area of law, it's particularly relevant. If we go back to 1947, Everson versus the Board of Education, Hugo Black for the majority, And Wiley Rutledge, for the dissent, insisted that we must interpret what they called the religion clause in light of its generating history. A few years ago, I wrote a law review article where I went through every single religion clause decision of the United States Supreme Court, and I find that basically everyone is an originalist when it comes to the First Amendment. But there's a key difference between conservative and progressive justices. Conservatives tend to get the history right. Progressives tend to get the history wrong. And so I think in this area of law, it really is important to get it right. So let me begin with religious liberty. And an important thing to note just from the get-go is that in the ancient world, religious liberty simply does not exist. It is simply assumed that the community will share a religion and that rulers will enforce that religion and punish dissenters